Hi, everybody. Today we're going to be talking about cyberbullying, a 21st century legal challenge for public schools. So, although school safety reforms have targeted cyberbullying as an emerging legal issue in public education, many states are still struggling with how to enforce off campus issues in particular. And because of the challenges establishing certain legislation regarding the scope of a school's interest in the safety and well being of its students, it is one of those things that can present very unique problems. So let's go ahead and dive in and first look at the definition. What is the definition of cyberbullying under Utah law? Well, here it is. Using the internet, a cell phone, or another device to send or post text, video, or an image with the intent or knowledge or with reckless disregard that the text, video, or image will hurt, embarrass, or threaten an individual, regardless of whether the individual directed, consented to, or acquiesced in the conduct or voluntarily accessed the electronic communication. What a mouthful. Well, that's the definition under Utah law. Obviously, it's any act where a student is using an electronic device to bully another student. Okay, let's move forward. So, the why. Cyberbullying was called by CNN writer Ashley Strickland, a serious public health concern. And if you're looking at the statistics right here on the screen with me, it says 34% of teens have been cyberbullied. 15% admit to bullying others. And this is just cyberbullying. We're not talking about bullying with the umbrella term. If we're looking at that, we're going to be closer to 50% or higher in most public schools across the country. Okay, so what is the impact on our students? Well, for me personally, I look at cyberbullying as the new tarring and feathering, and I'm going to use it as a strong metaphor for public humiliation because to me, it's meant to be as degrading as it is sinister in nature. And when we look online and we see headlines like this, Fox News, 2 preteens charged with cyberbullying after 12-year-old commits suicide. And this other one on ABC News, cyberbullying tragedy. New Jersey family to sue after 12-year-old daughter commits suicide. That is heartbreaking. This is something that should not be happening. These kids are far, far too young. Far too young. They're not even teenagers yet. I mean, 12 years old. Just process that. It's very, very disheartening. Looking at a recent report by the CDC, they are saying that 54% of people who commit suicide now have no history of mental illness. So we can't just say, well, maybe they had a mental illness. Maybe they were suffering from immense depression because of that mental illness. No, it's not a mental healthness. It's not a mental illness issue. It's a social issue. And in another journal that I read, it said that cyberbullying has a strong impact on all student behaviors. It increases suicidal thoughts by 14.5% and suicide attempts by 8.7 percentage points. Those are pretty big numbers too. And to be quite honest with you, they're just a little bit scary to me. Moving forward, we need to know our legal responsibilities, right? So there's a book I read, and it was called The Principal's Quick Reference Guide to School Law. And this is how they outline our responsibilities. It says, a school is responsible for addressing harassment incidents about which it knows or reasonably should have known. This requires school personnel to maintain high levels of vigilance to enhance school safety and security. It also requires all school personnel to take immediate action when they see bullying or have reports of that brought to their attention. Although schools may handle the reporting process differently, there are basic steps that should be taken every time. And one of the key things we need to be doing is documenting. And we need to be getting these kids help sooner rather than later. Okay, so now let's take a look at case law. Tinker versus Des Moines. We're all familiar with that. That case regarded the kids with the black armbands who were protesting the Vietnam War. And obviously, the court ruled that their freedom of expression had been violated because they did not create a substantial disruption with the form of protesting they were doing. Now, moving forward, that case really did help set the precedent for this next one in a way, because Kowalski versus Berkeley County Schools involves cyberbullying, but it also involves that freedom of expression. So let's take a look at it. Administrators suspended a student for 5 days because the student had created a myspace.com page and made defamatory statements on that particular page about another student. The student, Kara, who was doing the cyberbullying, decided to sue the school for violating her free speech. She alleged that the speech was private and out of school, so her rights had been violated. However, the lower court disagreed and upheld the suspension. The speech also wasn't made during a school-related activity, she said. Nevertheless, the district court ruled Kara used the internet to orchestrate a targeted attack on a classmate and did so in a manner that was sufficiently connected to the school environment. So by doing this, she actually violated the student code of conduct. There were anti-bullying policies in place in that student code of conduct, and because she violated that code of conduct, it was well within the school's right to suspend her based on that alone. But the court also determined her actions invited others to engage and indulge in disruptive and hateful conduct, and this constituted an in-school disruption, so the decision was able to stand. In that case, seems like justice was served. The girl obviously was guilty of bullying in this case, and even though it happened off campus, the school was still well within their right to do that because of those reasons. We're going to go ahead and move forward, and I'm going to cap off here. What did I learn from this project? Our school mission, vision, and codes for student conduct need to be written to account for the law and written in a way that protects students and the learning environment. Tinker versus Des Moines was a landmark case that we need to consider anytime we are examining students' constitutional rights. We always need to ask that question: is this creating a substantial disruption? Obviously, if it is, we need to make sure that it ceases and the students get whatever the consequences are determined to be. Bullying is a serious social issue, and we need to have cyberbullying prevention programs and places such as tip lines and hope squads to help students, because research shows students are more likely to say something to peers than adults. And finally, learning case law can help us to better understand how to put ourselves in a position to be successful when running a school and when dealing with student discipline. Now, finally, we get to the references page, and I just want to take a minute to say thank you for taking the time to watch this presentation. Hopefully you learned something new that maybe you didn't know before. And if you have further questions, feel free to leave comments, and I'll do my best to answer those questions. Thank you.